Hey, I am Aziza Zaharuddin. So today I will talk about tort of negligence. Okay, what is tort? A tort is an act or omission that gives rise to injury or harm to another and amounts to a severe wrong for which courts impose liability. In the context of torts, injury describes the invasion of any legal right, whereas harm describes a loss or detriment in fact that an individual suffers. Okay, next, what is negligence? Negligence is a failure to behave with the level of care that someone of ordinary prudence would have exercised under the same circumstances. The behavior usually consists of action, but can also consist of omissions when there is some duty to act. So, what is tort of negligence? According to Winfield and Jolowick, negligence is the breach of a legal duty to take care which results in damage undesired by the defendant to the plaintiff. While Lord Wright states that negligence means more than heedless or careless conduct, whether in commission or omission. It properly connotes the complex concept of duty, breach, and damage, thereby suffered by the person to whom the duty was owed. So there are several factors that need to be satisfied for an individual or company to successfully sue for negligence. They are duty of care, breach of duty, damage, and causation. Duty of care. Duty of care is an obligation or a burden imposed by law, which requires a person to conform to a certain standard of conduct. The existence of such a duty in a given set of circumstances has given rise to what is known in the law of torts as a duty situation. Based on case of Donoh v. Stevenson 1932 AC 562, the claimant successfully argued that she was entitled to a duty of care even though the deficient goods weren't bought, not by herself but by a friend, so that no contract existed between the manufacturer and the person suffering the damage. How to determine the duty of care? Lord Atkin and Donoh formulated a general principle for determining the existence of duty of care which came to be known as the neighbor principle. Neighbor principle. Lord Atkin states that the persons who are closely and directly affected by my act, that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called in question. You must take reasonable care to avoid acts or omission which you can reasonably foresee would be likely to injure your neighbor. Breach of duty. If a person owes a duty of care to another, a court will determine exactly what duties are owed. This is considered to be the standard of care. The standard of care which the law demands of a person in a normal case has been established to be the standard of reasonable care, standard satisfied by the hypothetical reasonable man. Clarifying the reasonable standard of care. The court will set the standard of care that they should have met. This standard consists of the actions which the court considers a reasonable person would have taken in the circumstances. If the defendant failed to act reasonably given their duty of care, then they will be found to have breached it. Who is reasonable man? Reasonable man is a fictional person with an ordinary degree of reason, prudence, care, foresight, or intelligence whose conduct, conclusion, or expectation in relation to a particular circumstance or fact is used as an objective standard by which to measure or determine something as the existence of negligence. First is the magnitude of risk. There are two ways the magnitude of risk affects the relevant standard of care. The first of these is likelihood of risk, and the second is the seriousness of the risk involved. Second, the importance of the object to be attained. It was reasonably foreseeable that you would be injured as a result of the other person's action or lack of action. And third, the practicability of precaution. The courts will take into account the cost of precaution when considering the applicable standard of care. The lower the cost of precaution, the more reasonable it will be held for the defendant to have taken it, and vice versa. For example, the case of Fardon v. Harcourt, Rivington, 1932, OER, REP 81. And the third element of negligence is damage and causation. For a person to be able to sue in negligence, harm as a consequence of the other person's action must be shown. Harm caused by negligence could be physical or mental. Causation requires the plaintiff to show that the defendant's breach of duty was the cause of the plaintiff's injury and loss. Another thing to consider is whether the defendant could have foreseen that his or her actions might cause an injury. If the action caused the plaintiff injury through an unexpected act of nature, then it will be deemed unforeseeable, most likely making the defendant to be found not liable. Damage are the final element of negligence because the plaintiff suffered injury or loss which a reasonable person in that same situation could expect or foresee. Monetary compensation may be the only form of relief for those injuries. Damage include medical care, lost wages, emotional turmoil, and more. For example, the manager of a sports equipment store displays heavy medicine balls on a flimsy top shelf. The shelf collapses and the ball starts tumbling down rapidly, striking a customer on the head and causing him to suffer a concussion. The customer has to miss several weeks of work and receive a pricey hospital bill. Monetary compensation will compensate the customer for his injury, lost wages, and the medical expenses. Let's see your understanding. Answer the question below.